Okay, in this class, we are going to be discussing the third of the substantive elements of patentability, namely novelty, arguably the most central requirement for patentability, possibly even a constitutional requirement for patentability. Essentially, the kind of fundamental concept here being you can only get a patent for an invention or discovery if what you've invented or discovery is actually new. And this ties into the purposes of having patent protection in the first place, namely incentivization of investment of innovation, right? We want to incentivize people to innovate, not to come up with inventions or discoveries that we already knew about, in which case they wouldn't really be inventions or discoveries at all. And also the disclosure rationale for patent protection, right? We want you to disclose something new. It's not a disclosure if we already knew it. You're just repeating something that was already available, right? So this concept of novelty as being a element, a kind of substantive, fundamental substantive element of patentability is really critical because it gets to why we give people patents in the first place. Okay. So it's also changed in recent years. So up until the America Invents Act, which went into effect in 2013, America's patent system had a concept of novelty that was governed by the Patent Act of 1952. And somewhat uniquely among international patent systems, it was a first to invent standard rather than a first to file standard. So essentially, under a first to file standard, the person who's entitled to claim patent protection over a particular invention or discovery is the first person to file a patent application for that particular invention or discovery. And the idea there is you want to provide an incentive for people to file patent applications as soon as possible. So as soon as you come up with the invention, you need to file it because if you don't file it first, then somebody else can beat you past the post. America was different up until the America Invents Act in that it had a first to invent system, which gave priority to the first inventor or discoverer of a particular invention or discovery, not necessarily the first person to file for patent protection. In other words, if you were the first to invent, you would be the person with priority to claim patent ownership, even if somebody else filed a patent application first. Now, under the American Invents Act, the United States system has shifted to a first to file system as well. But this is sort of a rolling shift, as it were, and the older novelty standard will still govern patent applications and, more importantly, patents that were filed under the previous patent regime prior to the America Invents Act going into effect. Okay, well, how do we go about determining then whether or not an invention or discovery is novel in practice for the purpose of patent protection? Well, we look to whether or not it had already been disclosed to the public. In other words, did people already know about it? If so, then it's not novel. If no, then potentially is novel, depending on the nature of the invention discovery and the disclosures accompanying it. Okay, well then, how do we know whether it was known to the public? We look to what's known as prior art, right? Which just essentially means anything disclosed publicly that people could have access to, whether or not they actually did have access to it. Now that could be, and frequently is, other patent applications or other issued patents, which are prior art and would, stand in for what's already been, or would indicate what's already been disclosed to the public. But any other kind of disclosure could work as well. And we'll talk in future classes about what would count as a prior art disclosure and how. But, for example, a scientific publication could be a disclosure, or something that was demonstrated publicly or shown to someone publicly that could constitute a prior art disclosure as well. Under the Patent Act of 1952, there was a grace period of a year with respect to printed publications after the invention or discovery had actually been discovered, right? So once you discovered, you had a period of time in which you could delay patent filing in order to further develop your invention or discovery. That has been limited to a significant degree by the American Invents Act of 2011. And we also have a shifting to the claiming rather than the inventing. Okay. So, what counts as a prior art reference and how it works for the purpose of the question of novelty has been streamlined, but the 1952 Act standards are still important insofar as many patent applications and issued patents are governed by the 1952 Act standard and will be until all of those patents have passed through the system entirely and everything's governed by the AIA of 2011. Okay, so how do we know whether or not a particular prior art reference constitutes anticipation, which would render the patented or the patented claim applied for, the claim applied to be patented to be anticipated by that prior art? Well, we got two elements we need to look to. Right? First, the prior art reference, the previous disclosure, has to be identical to the patented claim. In other words, every element of the patented claim has to be disclosed in the prior art reference. And this is sort of parallels how we think about patent claiming, right? So every element of a patent claim has to read on to an accused product in order for the patent claim to be infringed. Likewise, every element has to be of a patent claim, has to be anticipated by a prior art reference in order for the prior art to render the patent claim non-novel, right? Adding additional elements would mean that there was something in the patent claim that hadn't been anticipated. Now, could you put multiple prior art references together to anticipate a patent claim? You could. In many cases that would happen, or typically that would have to happen through the non-obvious requirement, not through the novelty requirement, right? So as long as the patent claim isn't entirely identical to a previous disclosure, then the novelty requirement is probably satisfied. In addition, there has to be enablement. So just like the disclosure in the patent has to enable the claim, so too the prior art reference has to enable the claim in order for it to anticipate the patented claim. Okay, well, let's think about how that works in practice in the Titanium Metals Corp of America case. So what happened here? We have some metallurgists who come up with a new titanium nickel molybdenum alloy with particular desirable properties. What are they specifically? Well, apparently performs well in hot, high saline environments, doesn't crack or get brittle, and so on, right? So what do they want to do? They want to get a patent over this particular alloy, and they submit a patent application that specifies the particular amounts of different metals that are in the alloy in question. Specifically, it's a primarily titanium alloy with a small percentage of nickel and molybdenum and very, very little iron in it. And it happens to have, as it says in the patent claim, good corrosion resistance in hot brine environments. Again, they specify a couple different versions of that same patent claim. What's the problem? Well, there's a prior art reference, right? So there is a short article in a Russian metallurgy journal that has been published 7 years before, which is relevant to the alloy that they are claiming. And so the question is, does the Russian journal article anticipate and enable the patent claims in question such that it constitutes a prior art reference, rendering the patent claims non-novel? And ultimately, the Federal Circuit determines that it does. Now, why is that? Well, because the Russian journal describes an alloy that has the same percentages of material as does the alloy claimed by the patent application. In other words, they show a range of different potential alloys that you could create, and the claimed alloy falls within the scope of the alloys that the Russian Metallurgy Journal article identifies. Therefore, the court says the alloy that you want to claim is non-novel because it is fully anticipated by this Russian journal article. Now, why does the Russian journal article satisfy identity? Right. Well, because the range of different alloys it describes covers the ranges that are claimed by the patent application. Why does it satisfy anticipation? Well, essentially the court says, look, a Fozita looking at the article would know everything they needed to know already about how to make an alloy of this kind. After all, a Fozita for a patent relating to metal alloys is basically a metal alloy engineer, right? A person in the business of creating metal alloys, and a person in those circumstances wouldn't need you to tell them how to go about creating a metal alloy. They would already know that. What you'd be telling them that would be of interest to them would be the particular percentages used and their relationship to one another in the alloy, right? Now, key question here is, well, what about these special properties, right? I mean, of course, the reason for this alloy, the utility of this alloy, is that it has good corrosion resistance in hot brine environments. And the Russian journal article didn't say anything about that, right? The Russian journal article didn't discuss the properties of the alloy in question. So why is it that the patent claim is anticipated then? Why is it non-novel? The problem is that the patent application is trying to claim the alloy qua alloy, not just the particular property of the alloy that has been identified, but the alloy as a whole, right? And so, the fact that they're trying to claim the alloy as a whole means that the only thing the Russian Metallurgy Journal article has to do in order to anticipate the patent claim is to describe the alloy as a whole, right? The fact that the journal article doesn't describe the properties of the alloy doesn't matter, because that isn't what the patent application is claiming, right? The patent claim goes to the alloy itself and describes one of the properties of the alloy, but isn't claiming the property, right? It's claiming the alloy itself. Now, the court also briefly discusses the non-obviousness requirement. Why? Right? Well, because the third claim falls slightly outside of the scope of the alloys described by the Metallurgy Journal. And the court says, yeah, but that doesn't matter. It's essentially close enough, right? A Fozita looking at the Russian Metallurgy Journal article would say to themselves, sure, they've described this particular range of potential alloys, but the metallurgist in me knows that alternative ranges are also popular, and the third claim definitely would fall within the scope of the additional potential ranges that would occur to a Fozita under the circumstances. So, question for you here, right? If you wanted to save this patent application, if you wanted it to be valid, how would you change it, right? What would you do in order to make it a valid patent application? And to the extent you can come up with a way you would change it, why do you think that the people applying for the patent wouldn't have done that themselves, right? I mean, surely they could think of a way to have framed these patent claims in order to make them not anticipated by what was described in the Russian Metallurgy Journal article. Why didn't they do that? Why do you think they wrote the patent claims the way they did, as opposed to writing them in a way that wouldn't have been anticipated?